SJC-12634, Veolia Energy Boston, Inc., v. Board of Assessors of the City of Boston.
Mr. Ambriano, good morning.
Morning, Mr. Chief Justice. Anthony Ambriano for the Board of Assessors of the City of Boston. This matter involves an appeal by the Boston Assessors from a decision of the Appellate Tax Board exempting from local property taxation poles, underground conduits, wires, and pipes owned by Veolia in the City of Boston for fiscal year 2014. Now, Veolia at all times material to this case was classified by the Department of Revenue as a manufacturing corporation. The assessed value of the property at issue was approximately $63 million, and the tax levied by the assessors and subsequently abated by the Appellate Tax Board was about $1.9 million. This court took the case on direct appellate review from the appeals court.
You have a little squabble going on about the burden of proof. Deference to the Appellate Tax Board, statute de novo, burden on the taxpayer seeking the exemption. Who's got the burden of proof here?
The assessment is presumed to be correct. I think that's well-established law. The taxpayer must prove its entitlement to an abatement or an exemption. With respect to the particular exemption that we are talking about here, sometimes generally referred to as the manufacturing exemption, although the term machinery does not appear in Clause 16.3, so it's sometimes called the machinery exemption or the manufacturing exemption. But this is a clear issue of law and statutory interpretation. That is what is now before this court, and that, in fact, is how the Appellate Tax Board treated the case. The Appellate Tax Board took a global view, shall we say, of the property at issue and determined that, as a matter of law, as a matter of statutory interpretation, the property was exempt from taxation. Now,
Do we have to overrule the great integral machine doctrine to get where you want us to go?
Not at all, Justice Gaziano. The great integral machine doctrine, first enunciated in 1866 in the Lowell Gaslight case. A couple of things to note about that case. First, it was not a property tax case at all. It was an excise tax case. The issue in that case was the computation of the excise tax on corporate shares and what the value of what property would be deducted in arriving at the final excise tax. The second thing to note about that case, it was not an exemption case.
But we've carried the doctrine over through in different contexts for over 100 years, right?
Well, I believe that's a great overstatement. And the most important change since the decision in Lowell Gaslight was the statutory progression that now created in 1921 a separate, distinct class of property subject to local taxation for manufacturing corporations. That category being poles, underground conduits, wires, and pipes.
And am I right that was before machinery became an exemption?
That is correct. The
And
machinery,
that's important, isn't it? That was 1936 when the machinery becomes an exemption, and then the pipes become an exception to the exemption.
well, the pipes were in before that.
Yeah.
Before 1921,
Yeah.
all property was exempt except for real estate and machinery used in manufacture. So essentially, there were two classes of property that were taxable. After 1921, There were three classes taxable: the real estate, machinery used in manufacture, and what was added by the 1921 statute, poles, underground conduits, wires, and pipes. Three categories, classes, as distinct classes subject to taxation. In 1924, the legislature created so-called manufacturing corporations. And in 1936, as pointed out by Justice Lowy, the machinery became exempted. So out of those three categories, one category was deleted. The machinery category was deleted. The other two categories, the real estate,
What do you mean deleted? You mean exempt from taxation?
it became exempt, correct.
Okay, yeah,
Dealing with exceptions to exemptions is
right.
sometimes verbally awkward, but that's essentially, in unambiguous terms, what became taxable in 1921 and was not affected by the later manufacturing machinery exemption: poles, wires, underground conduits, pipes. So I think, in answer, going back to the question, at this point, Lowell Gaslight is of very minimal relevance to this case.
That would be great, except for Lynn's, what is it, Lynn's Stone and Sand?
Yes, the Swampscott case, which first was a real estate tax case, not a personal property tax case. And I think the important thing about the Swampscott or Lynn Sand and Stone case, which again did not even address the issue of the great integral machine, the issue in Swampscott was whether certain property that had been designated as machinery, because of its bulk and its degree of affixation to real estate, became real estate. And that case did not deal in any way with the separate category that we are discussing here today, the poles, underground conduits, wires, and pipes.
But can I just ask you, fact specifically, it seems like the appellate tax board looks at these pipes as necessary to keep the steam useful. I'm oversimplifying. So it's not like it's just an oil pipeline that sends the oil somewhere to Chelsea Creek or something like that, but it performs part of the manufacturing process, or at least it keeps it, I don't know how to describe it. It makes the steam provide power. And if it's not sophisticated in doing that, nothing happens. So isn't that part of the machinery of the manufacturing process, I guess?
Well, I would point out that,
And feel free to say I'm wrong on the facts, but that was my understanding of what the ATB is saying.
well, with respect to the facts first, the ATB did not specifically find that individual pipes were themselves machinery.
Right, but it's
The
fine.
appellate tax board only found that the entire apparatus was a great integral machine.
Right.
The statute, as it now exists, Clause 16.3, makes pipes taxable as a distinct class of property. And the fact that, for example, the derricks, the silos, and the type of property at issue in the Swampscott case.
Right, but could you answer my question, though? If we have pipes that are necessary to manufacture the steam, they're not just delivery devices, but they're part of the manufacturing process, isn't that different? Can't we have two different kinds of pipes? And don't we then have to defer to the ATB in fact-finding?
I would answer that question by saying that the statute itself makes pipes taxable.
I
And
can read-
and there's no statutory language, there's no ambiguity, there's no uncertainty in the words pipes. Pipes are taxable.
So does that mean?
But you wouldn't claim that a pipe that's within the building would be taxable? Because,
No.
I mean, we're dealing with, when is a pipe a pipe?
I think that's right, and in fact, going back to the Swampscott case, the essence of the Swampscott case was whether this very bulky machinery could become real estate. And in the Swampscott case, and this court is well aware, there's a lot of case law that involves degrees of affixation of property to real estate and whether or not that makes it real estate. I think Swampscott stands for the proposition that if it is machinery and it is bulky, the affixation case law may not strictly apply to that particular machinery. So I think that Swampscott says there's no distinction between bulky machinery and less bulky machinery.
But I think the question that was before you, that Justice Kafka is asking, that I don't know if you've answered, is that the expert had said that there's manufacturing going on within the pipes. And if that's the case, and that's the factual finding, doesn't it make the pipe part of the machinery of the operation?
I disagree with
Now,
that.
whether that's true or not, that remains to be seen, but that's, I think, was the expert's testimony, and that's what we have to struggle with.
No, I understand the expert's testimony, understand the appellate tax board's very global view of the entire process, and certainly the steam doesn't get from the boiler to the customer
There's also-
without a pipe.
Right.
There is no doubt about that. But the statutory language, and remember, the word machinery does not appear in clause 16.3. Everything is exempt except for real estate, poles, underground conduits, wires, and pipes, which are categories of taxation submitted by the legislature without qualification.
And they're not defined anyplace?
Excuse me?
They're not defined anywhere in the statute? The word pipe?
No, it is not.
Don't you have to, just going back to Justice Kafker's bottom line question, don't we have to defer to the fact finding of the board?
No, because even if, we view this case as a case of statutory construction. And first, I would again point out that the appellate tax board never found that the pipes themselves were machinery. The board did not get, as was the case in the Swampscott case, the board never made specific findings as to each item of the property at issue. So therefore, there's no finding that a pipe is machinery. And again, I think our view of the case is one of statutory construction.
So let's go back to that, to statutory construction. You say it's basically the plain language of 16.3 that the board ignored?
Yes.
And how would you, if you were faced with the board again, what would you say to them to make them understand why they were wrong?
What I would say to the board was you cannot disregard the plain words of the statute, and the board, in its findings, jumped immediately to an 1866 case, which was not a property tax case, and which was decided long before pipes became a specific, distinct item of taxation.
But you would agree that there are pipes in machines that wouldn't be taxed?
There is no doubt about it, and there's certainly, a list of horribles that both sides can present to this court and say, well, are you going to try and now tax pipes within a combustion engine? That has never been attempted. There is no doubt as to that.
But the language of the statute says poles and underground conduits, wires, and pipes. Am I correct that the underground relates not only to conduits but also to wires and pipes? We're only speaking about underground wires and underground pipes.
I would disagree with that. That specific issue has never really been decided. That language appears in various clauses and in some other statutes too. But it's underground conduits, wires and pipes. So we would have a very distinct issue, Chief Justice, with respect to whether only underground pipes were taxable, and certainly there was no finding by the appellate tax board on that issue, nor was it argued
Are we
at the
are
appellate
we
tax board.
dealing with any wires and pipes here which are not underground?
Yes, there are some here. There are some crossing the Charles River, I believe, underneath the Longfellow Bridge.
Can I ask you, just because I like saying great integral machine, can I ask you about your assault on that doctrine? You told us, when I asked you originally, that it was kind of a dead letter, but we have it in 1947, 1956, 1979, and 1985 recognized by this court, albeit grudgingly in 1979. But the court said, hey, we're stuck with this. It's been the law for 90 years. We're not going to change it. Isn't that our response here?
I hope that is not the response, because the statute has changed, and the specific issue that is raised by this appeal is whether the distinct class of property made taxable to manufacturing corporations essentially means what it says. And that issue wasn't really in Warner-Amex. In Warner-Amex, the assessors attempted to use the great integral machine theory and to tax an entire apparatus as machinery used in the conduct of business. And the ATB in that case said what the assessors are now saying to this court, which is, well, wait a second, no. Wires and poles are now a distinct class of property. You can't include that as machinery. So we are essentially, the city is now essentially saying the same thing to this court.
Didn't they draw a line between what's conveyed from the plant? You know, they made a distinction between telecommunications versus steam and gas, essentially.
Yeah, the court said in its, I think, as you characterized it, reluctance following of the policy. But the fact of the matter is that the words of the statutes are the same. Machinery appears in clause 16.1 and 16.2, doesn't appear in 16.3. So neither in Warner-Amex nor in the Boston Gas case. And the interesting thing about the Boston Gas case is that the parties had stipulated that the pipes were taxable. So that had nothing to do with this court's decision in Boston Gas.
So are you saying that machinery is not exempt from taxation?
Machinery
Is exempt?
is exempt.
So it's a question of what constitutes a machine?
Well, it's a question of what constitutes machinery, but before that, the more basic question is whether the property at issue is specifically made taxable by 16.3.
Wait a
Is it-
second, wait a second. You're saying that if you, even though it's machinery, it's not, it's taxable if it's, a part of it is a pipe?
No, if to go back, if to
16.3?
the extent that a pipe is, for example, in an internal combustion engine or in a diesel engine or is used to transport fluids within a boiler, that is not something the assessors are looking to tax.
It has to be a freestanding pipe?
This is generally freestanding pipe that was at issue in this case, correct?
Right, I understand that, but if it's considered a component of the manufacturing,
Whether it's a component of manufacturing or not, I don't think is relevant under the statute. The statute says the pipes are taxable.
What if the pipes are indispensable to the delivery and the finished product doesn't become a finished product till the valve allows the steam in? What about that?
That is not an exception to the exception recognized by the statute. The statute says the pipes are taxable. It makes no differentiation between pipes used in delivery, insulated pipes.
then why are pipes within an engine wouldn't be taxable?
Excuse me?
Then why did you make an exception for some pipes?
Well, we would make an exception. In some engineering literature, there is a distinction between pipes and tubes. Tubes sometimes being referred to as smaller pipes within, for example, an engine.
Does the legislature know about that?
I don't know, but I think clearly what they knew in 1921 was tax the pipes.
Okay, what's an underground conduit?
An underground conduit is typically a cement structure that goes underground into which cables and/or pipes are placed.
Is it round?
And so you're saying that the legislature intended that only underground conduits be included, but not underground wires and underground pipes?
I think if they had meant underground to go further, they would have said so. Again, that issue has not been,
One could argue that they did by having poles, which clearly are not underground, separate.
correct.
So it didn't say underground conduits, wires, pipes, and poles. It said poles and underground conduits, wires, and pipes.
Underground conduits, comma,
Well, of course,
wires and pipes.
comma. If it wasn't a comma, it would be a problem. But they have to have a comma, but
So what does
wouldn't
the-
that solve this dilemma of which wires and pipes we're talking about? Because it would obviously not be underground if it were within the machine.
Well, there are no specific findings in this case as to what pipes were above ground and what pipes are below ground. Certainly it would be the city's position that Clause 16.3 makes no differentiation between underground and above ground with respect to pipes.
What
so-
about
and
the
so how would we
absence of the
distinguish
comma after
between-
wires?
I'm sorry, I couldn't,
The absence of the comma after wires, does that change anything?
I don't believe so.
And so how do we distinguish then between wires and pipes within the machine versus wires and pipes outside the machine?
Well, it would be the same types of arguments, Chief Justice, as there would be with respect to whether freezers are affixed to real estate and become real estate. I point out that the absence of case law on what is a pipe indicates that generally assessors and taxpayers have figured it out. And in fact, the Department of Revenue, in its forms of list used for reporting purposes by corporations, breaks the categories up quite distinctly: machinery, poles, wires, et cetera.
You have an argument, I think you do, in your brief about if the interpretation is consistent with the appellate tax board, that the sky is going to fall down. Is there any, what happens in with other municipalities as it relates to pipes and machines in Clause 16.3 and the exemption and the exception?
There is very much a dearth. This issue, frankly, does not come up very often. And this is really a case viewed by the assessors as a case of first impression. What does the statute mean? What does Clause 16.3 mean?
When it doesn't come up very often, does that mean that municipalities are taxing the pipes or that they're not?
I simply don't know the answer to that, but I would point out that under the system of personal property taxation, and not only in the larger municipalities such as Boston, but in the smaller municipalities in particular, it's the taxpayer who decides what they are reporting. And they report it on the categories on the Department of Revenue form of list, and those categories may or may not never be audited by local assessors. It's an expensive proposition. It's time consuming, particularly in the smaller municipalities.
Okay, thank you.
Okay, thank you.
Ms. Gregor?
Good morning. My name is Kathleen Gregor, and I represent the appellee Veolia Energy Boston, and I am joined today by my colleague, Erin McGowan. And may it please the court, I want to actually start with one point of clarification from Mr. Ombriano's arguments. There was an extensive back and forth about whether or not the board did find or did not find that the pipes constituted machinery. And I would just like to draw your attention to page 208 of the board's findings of fact, the very last line, in fact, before the summary of their findings, where they state that the board found Mr. Wall's testimony credible and agreed with his conclusion that the networks, including the subject property, and here he refers, or the commissioner refers to subject property as pipes and appurtenant equipment, and then it says, constituted and operated as a single integral machine. And so in that sentence, the board is explicitly finding that the subject property constituted machine. And that's clear from the findings. It's also clear from the findings that these pipes and the appurtenant equipment serve several critical elements to the manufacturing process. And in fact, as has been noted earlier, they are necessary and integral to the production of steam to be delivered in a manner demanded by Veolia's customers.
Can I ask a question?
Yes.
I'm not an electrical engineer, and I don't really understand it, but the wires and poles that deliver electricity, I take it we can't get that without those wires and poles either, right? Are they essential to the manufacturing process the same way that steam is essential to the, do the wires and poles out there in the world perform the same function that the pipes do in the steam context?
I suppose it would depend on whether or not it would depend on which of the two sub clauses to clause 16 you are in.
Well,
Honestly,
I'm trying to make sense of the exception.
Sure.
And you
Yeah,
do a really good job of explaining why those pipes are part of the machinery. But then I look at the poles and wires, and I start saying to myself, maybe they wanted the municipalities to be able to tax that stuff, and then it seems analogous to what you're talking about. Then I get nervous.
well, it could be analogous, certainly. And before 1936, Clause 16.3 was analogous, or the predecessor to Clause 16.3 was analogous to 16.1, where there was the distinction between pipes and wires that were machinery and pipes and wires that are not machinery was meaningless. But I would direct you to the decision in in Boston Gas, where this court held, because there is a difference under Section 18 of the statutes that allows cities to tax wires differently, particularly wires that go over public ways, differently than wires that would be part of machinery. And there they extended the great integral machine doctrine to decide that wires, even though they might otherwise fall into the stated exception, should instead be treated as machinery. And so it's important, this court has found that even though the separate word wires exists in 16.1, instead, if they are integral to a manufacturing process.
So give me an example of a pipe or a wire that would be taxable. If I've got an oil company that manufactures oil, but it has pipes that go all the way to Chelsea Creek, are those taxable or not? Because that oil doesn't, I assume it's just a pipe, right?
Certainly. So if you were not considered a utility, in other words, if you were a manufacturing corporation.
So I make oil.
You make oil. If you make oil and there was and it was integral to the production of your product.
It doesn't do anything. It's just a pipe that
Then
sends
it probably would be taxable. A passive pipe is taxable.
So a
If it's
passive
not-
pipe and a passive, give me an example of a passive wire.
A passive wire. Perhaps if you bought and resold electricity and all you did was deliver it, or you bought and resold
Don't
information.
those wires do the same thing your pipes do? They keep again, I was a history major. I don't know how this works, but they keep the electricity flowing through the pipe properly.
So they keep the electricity flowing, but I think what this court in Warner Amex has done as distinct from the Boston Gas case is to say what matters when defining a machine is whether or not the component parts are working together for a common end. And in both of those cases, they looked to the common end differently depending on whether you were in a manufacturing context or not. So if you did just buy information, if you owned wires, you bought information and you just passed the information through, or you passed electricity through those wires, that's passive. That you might have little machines along the way, like in Warner Amex, but the wires themselves were not working together with the other components.
But that was the cable TV case, right?
That's the cable TV case.
Right, but isn't it critical to me getting cable TV that I have a converter and that it come to my house?
Sure, but the definition of machine that this statute, or that this court has adopted repeatedly over time, is not whether or not it's critical to the customer, but whether or not the component parts of that you're looking at, whether a collection of mechanical means work together for a given end.
And I get that it really comes back to whether or not it's attached to manufacturing at the front end, right?
Yes.
That's the distinction we're trying to
That
draw?
is the distinction. And when you're in a manufacturing process, what this court has found is that the definition of machinery looks to the given end of the manufacturer
Versus-
product.
And that's the aqueduct case, where there's no manufacturing.
The Dudley case, exactly, where there was no manufacturing and instead these were merely passive pipes that were being looked at. And in fact, that brings me to an important point in looking at the word pipe in the statute itself. I think the city would have you use the same form of tunnel vision to look just to the word pipe in the statute, just like it wants you to look just to the pipes that exist in our broad machine. But in reality, you would need to look at what the word pipe, how it was taxed at the time that that word was added to the relevant statute, which actually it was technically added in 1921 when the legislature reworked all of the relevant statutes, but in fact was originally added in 1905. And in 1905, there were two, if you looked to, say, Veolia's district energy system or the Dudley case's aqueducts, you would see that there were two different types of pipes. There were machinery pipes and non-machinery pipes. And at the time, machinery pipes would have already been taxable. So by adding the word pipes to the statute in 1902, not 1905, in 1902, and then again reorganizing it in 1921, all the legislature was doing was causing non-machinery pipes to become taxable. That was the only effect of its change.
But it puts it in the context of that phrase, underground conduits, wires, pipes, and poles. Does that suggest they had something particular in mind? Or kind of manufacturing that generated that statement?
So I don't know if the words suggest that there was a particular kind of manufacturing, but I would posit that it likely was in reaction to the Dudley case, where you had a situation where, for example, the Lowell Gas Light Company received a full exemption from taxation on, received or had to pay full property tax on its pipes as a direct result of the Lowell Gas Light case, but on the flip side, the Dudley case held that passive pipes were not subject to tax. So based on the law at the time, which this court is imputed with knowledge of, the legislature is imputed with knowledge of this court's prior decisions, based on the decisions at the time and that distinction that had meaning at the time, all the legislature could have done was to add in non-machinery pipes to the statute.
So why should we keep the doctrine going when Chief Justice Liakos at one point said it makes absolutely no sense?
So it does make sense. To draw a distinction, I mean, I would draw you to the case, the decision in the Newbury case, where it looked at, it was in a different context, but it did look to the definition of machinery, and this court was asked to draw a distinction between certain types of machines, and it chose to interpret the word machine broadly, and that would be consistent with the Lowell Gas Light case. To do differently, and this goes to the question of sort of whose interpretation perhaps is more absurd, I would posit that drawing a distinction where you need to separate out pipes, whether they're underground, above ground, or not, when they are otherwise integral to the manufacturing process, would be absurd. You would end up with breweries having to separate out the pipes that connect their various vessels for the entire step of the process. You would end up with pipes, for example, in the enzyme manufacturing that this court looked at in the Genentech case. You would need to separate out the pipes that connected the various vessels that grew the enzymes. And taxpayers wouldn't instinctively know to do that. I think it's absurd to say to a taxpayer, you're a manufacturer, you get an exemption on all of your machinery, but then ask the taxpayer to stand in front of a car and say, okay, I don't see a car, I see a collection of pipes, wires, and some other stuff.
Did you do a legislative history? Knowing you guys, I suspect you dug deep. So was there a legislative history on this in 1902? I plugged in Alexander Graham Bell, and it says the telegraph and telephone industry is stimulated in 1895, whatever. I'm just trying to figure out, are telephone poles taxed?
Telephone poles are taxed, although there is a distinction on which town gets to tax them based on Section 18.
So is there any possibility that this statute is just meant to deal with telephones and?
It is, although,
By the way, is that what the legislative history shows?
so there's very little legislative history in 1902, at least that we could find. We did dig as deep as we could.
Yeah, I figured you would.
Yeah, there is very little to be found. Nothing nearly as good, I would say, as the 1936 legislative history, which has a commission report that made clear that the legislature intended, in the height of the Depression, to exempt all machinery of a manufacturer from local tax. We couldn't find anything like that in 1902. All we have is sort
But
of
why is
general
that so good for
context
you? Because it did not knock out pipes,
included in machinery.
poles, underground conduits, wires, and pipes. It expressly said those are still taxable.
You mean in the statute that was
36
enacted?
statute, it said, okay, we're going to knock out machinery, but we're going to leave in as taxable underground conduits, wires, and pipes. So they made.
And real estate.
And real estate. They
And
made-
real estate. And this court has decided both in Lynn Sand and Stone and effectively in the Boston Gas case, that simply because the words are contained in the statute doesn't mean that if something is machinery, it is treated as those things. I mean, we would posit that in defining pipes, you would have to include only non-machinery pipes.
Is this a factual question, really, or is it a question of law? I mean, it's starting, to me, to sound factual in nature.
So I believe our position is that it is a factual inquiry as to whether or not something is a machine. If it's a machine, the inquiry simply stops at that point in time because there is a general broad exemption for machinery from local tax.
So that means that now every tax assessor has to determine whether a pipe is an active pipe or a passive pipe. And you can't even describe to us how we are supposed to do that. So how are the tax assessors supposed to do that?
So I believe the tax assessors can do that quite easily to see whether or not the pipes are used within a manufacturing process.
Okay,
And
well, I mean, so with regard to cable, are they active or passive?
they are passive, but that's because it's not a manufacturing process. The
Okay,
end
how
result
about-
in
how
that
about
case is not the production.
Electricity?
In electricity, it's a meaning without distinction, but this court has found that wires used when a company is in fact manufacturing electricity, as opposed to buying and reselling electricity, this court has held in the Boston Gas case that those wires are part of the great animal machine and should be taxed as
But
machinery
I
and
thought
not
your brother
wires.
said that in Boston Gas, they were not even challenging the tax, that they were not saying that our pipes should not be taxed. They
So
didn't
there
raise
were
the point.
two, in Boston Gas, there were two divisions there was the gas division, which they conceded that pipes were taxable, so it wasn't before the court, because in that case, the pipes would have been taxable whether they were machinery or not. Because remember, we were in 16-1 in that case. And instead, but if you look to the second half of the opinion, when it looked to the electrical department, they held that the wires were machinery. And that was relevant. That was a relevant inquiry, not because of whether they could be taxed or not. They could be taxed. But then if you look to Section 18, the decision on who could tax it, in other words, a particular wire, if it was a wire going over a public way, it would not have been taxable. But as part of a machine, the municipality in which the machine existed could tax it. And so it actually was a legal determination there that mattered. And this court held that those were not wires, that was machinery. And so in a sense, machinery used in manufacturing.
But you had an expert testify, and the chief's question is, how is an assessor supposed to do this when you had to call an expert? And frankly, the opinion, the steam that's pressurized from your client and it goes through the system, it doesn't change what it is. Nothing's manufactured, it's still steam. It gets pressurized, depressurized, there's expansion joints and reductions, but it's still steam.
Well, I would put to the court that in fact the difference between 15 psi steam and 100 psi steam is actually materially different. And what the steam that comes out of the production facilities is generally speaking coming out at around 200 psi. And the steam that exists in the pipes, effectively in storage, waiting to be turned into what the clients demand, hovers around 100 psi. And that is extremely different than something that is more in the neighborhood of 15 to 50. You can't just shoot the steam directly out.
I
You
would
have
hope
to
not,
actually
right.
convert it.
But, so that's what the assessor has to look at to see how the material is being changed?
I think the assessors need to look at how the pipes are being used, and if the pipes are being used as part of machinery used in a manufacturing process, then it's exempt. And I believe,
So, all
I'm
right,
not a,
so if I get a cable system and the signal comes out to my house and I need a box to convert it into, isn't that a change?
well, this court has held that conveyance of information is not manufacturing. And so the mere fact of change
Which
in
is
a
why
resale.
Justice Liaco said this makes no sense, right?
In that context. It makes no sense in that context because all you're doing is buying information, conveying it, and reselling it. There, the cable
Sometimes
boxes are not actually.
manufacturing it.
Sorry?
Sometimes we manufacture it.
Sometimes you manufacture it, and I think maybe that case could have come out differently if someone controlled the entire process. But in reality, the cable boxes are not changing the information. They may be limiting you to what you purchased. In other words, the cable boxes may be saying, all right, you signed up for these first 10 channels, but not the next 10. And so therefore is limiting you to just what you signed up for and paid for. But they're not actually changing the nature of the information coming in. That is simply the information that Warner had purchased from third parties
So
and was
give us,
conveying to its customers.
give us the standard we would use, rather than using that great term, great integral machine, and then there was a thing about whether or not it's part of one continuous, whatever that language was. What's the test we say to the assessors?
I think you would look to whether or not, assuming you have a manufacturing corporation, you would look to whether or not there is a collection of mechanical means that are working together to produce a given end. And if the pipes simply are passive pipes that bring water into a building, or if they're sewer pipes that are taking something away, and they're not actually working together with other mechanical means to produce something, then they can tax them. If not, if it's in a combustion engine, if it's in a brewery, if it's a part of the district energy system of Boston, it is part of the machine that is producing the product.
The appellant makes, I won't say a big deal, but it's important to them to say that Lowell Gas wasn't a personal property tax case, that Lynn Sand wasn't a personal tax case, and this is. Does anything result in that, from that?
No, in fact, taking a step back and remembering how the tax system works for corporations in the Commonwealth, it's not really if you're exempt from property tax, you're not really exempt from tax. It's actually a division of authority as to who can tax the value of a corporation. And so if you look to Lowell Gas, that was a case against the commissioner, because the commissioner was in a dispute with the taxpayer over, and this is Lowell Gas Light, the earlier one, but was looking at whether or not the taxpayer had to pay excise tax on the value of its property. But then the negative implication of that decision is that if it was deductible from the excise tax calculation, then that meant it was taxable to municipalities. So by deciding that the pipes are machinery, which is was at that time subject to local property tax, that meant that there was it's sort of the flip side of that, which is what was before this court then, is that it was a deduction from the excise tax calculation. So even though it was an excise tax case, it was looking at the same issue. These are sort of mutual provisions that work together.
Can I ask you a simple question?
Yes.
What's really in dispute here? Is it a factual question in which the ATB's decision is dispositive, or is it something else? And in connection with that, let me just try to twist this around. Suppose, even though you had the expert testimony and so forth, the board found it's not a component, it's just a pipe.
So if the experts found,
Would you be arguing before us as a matter of law or as a matter of fact?
I think preliminarily you have to have a finding that it's machinery. We think that once you have a factual finding of that something is machinery, that it falls within the accepted legal and scientific definition of a machine, which are blissfully consistent here. Once you have that factual finding that something is a machine, then we think that the inquiry ends as a legal matter, but we believe we're here today the city has asserted that as a matter of statutory interpretation, that the machinery exemption should not be viewed as an exception to pipes or baked into the definition of pipes.
And has other municipalities looked at this issue?
Sorry?
Other municipalities looked at this issue at all that you're aware of?
We're not aware of it, other than the cases that have come before this court.
Okay, so flipping it around, suppose you didn't get the fact-finding you wanted, where are you? Can you appeal that?
If we didn't get the fact-finding that we wanted, that the pipes were integral components to the machinery, then...
Despite the supporting evidence.
Yeah, I mean, I would just say first, the city has not actually raised a sufficiency.
I know, but I'm just trying to understand
So if
this.
if these were not considered machines, then no, I don't think we would be standing here today.
Okay.
I think that if these were passive pipes that were not part of the machinery, they would be taxable.
If they were determined to be passive as opposed to,
If they were determined to not be machinery.
Right.
Because the machinery exemption is broad. I mean, this court has repeatedly held that it is broad, and for the reason that anything else would result in sort of absurd results or complete inability of taxpayers to determine what was taxable and what wasn't. I think in Newbury it was said sort of best, where they basically said you have to, anything that could colorably be a machine needs to be treated as machinery for purposes of the statute, or else taxpayers would have no way. It would sort of be something that's constantly relitigated. And so from our perspective, if something is a machine, it ceases to be a wire, pipe, or real estate, and that is consistent with Lynn Sand and Stone. It's consistent with Boston Gas and Lowell Gaslight.
If it's not, it's not.
If it's not machine, it's not. It's not, exactly. It is whatever it might otherwise
But
be.
even if you thought the ATB was wrong.
Well, I suppose we could argue something, some kind, we could mount a sufficiency claim ourselves and say that their finding was contrary to evidence presented, but I don't think in this case we certainly are perfectly happy with the ATB's findings, but I don't believe the city has mounted a sufficiency challenge.
Okay, thank you.
Thank you.